Hi, my name is Vlad Genshu, and I am a civil jury trial attorney in Los Angeles, California. I practice mostly out of Los Angeles, and I'm admitted to practice throughout all of California state courts, and I've tried jury trials in three counties, Los Angeles County, Orange County, and San Diego County. I want to talk to you today about direct examination. The first thing to remember, and if we summarize this entire video in one sentence, is direct examination is about the client. The client is the star. The client is the star of direct examination, not the attorney. Johnny Cochran said that the key to litigation and trials is preparation, 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 and luck is the intersection of hard work, timing, and preparation. I read that in his book, A Lawyer's Life. I really look up to Johnny Cochran. I went to the same law school as him, and I think he was a great lawyer. And I can't stress enough that you'll get luckier in life the more you prepare. The more you prepare, the luckier you'll get. So the bottom line is, when you are preparing your direct examination, there's some simple rules, which you cannot lead your client. None of your questions can be leading, right? And when you think about that for a second, you want to think about, what is the purpose of direct examination? Direct examination is an examination of witnesses that basically are friendly to you, be that the expert witness that you've retained, the medical doctor, the accident reconstructionist, the biomechanical expert, the billing expert, or your client. So when you're doing that, right, these are not adverse witnesses. You can't lead them. You can't cross-examine them, if you will. What you need to do is you need to realize you want to get their story out. And the best way to get a story out and to paint the picture of the facts that occurred is to let your client do all the talking, which means, just like in a deposition, just like for trial, the real work, the homework, if you will, is done at home. It's done in your office. You need to prepare your client so that they remember everything that happened, so they remember the facts and of the case. So here's the most important thing to remember. The attorney is not the star on direct examination. The client is the star on direct examination. The client needs to paint an accurate, truthful picture of how the accident occurred, how it impacted their life, the medical treatment, and so on and so forth. Which, the way it really should work is, if you think about it, you should ask, basically, other than the first questions, were you born, et cetera, how long have you lived here, you should really ask open-ended questions so that your client on the stand, goes on and explains this in paragraph form. So if you say, here's a question, after you talk about, the basics about your client, let's just say that you want to paint a picture of where your client's from. So you want to say, good morning, Mr. Martinez, how are you today? I'm fine. And then you ask him, Mr. Martinez, have you ever been in court before? He says, no. You a little bit nervous today? He says, yes. I've never testified before in court. This is my first lawsuit. And then you ask a question, Mr. Martinez, or Miss Smith, or Miss Jones, or Mr. Alvarez, can you tell us where you're from? And you don't want the client just to give you a one-sentence answer, because remember, the jury's hearing all this, right? And the jury's evaluating everything. There's a California jury instruction that says the jury can evaluate somebody based upon their demeanor, the way they say things, the way they look down. If basically their bottom line is the jury is using their common sense to evaluate your client, to evaluate the other side, to evaluate the experts. They are the judges of the facts. So the way they do that is they apply the law that the court gives them, the judge gives them, but they use their common sense. And the best direct examination is a conversational approach where it's like you're talking to your friend. And that's very difficult for a client because, lawyers might have tried a good amount of cases. Expert witnesses are probably really good at that because they might have been, deposed or numerous times and testified in court numerous times. But your client is many times is not going to feel comfortable in court. They're going to be intimidated. It might be a big courtroom like in Spring Street, or it might be a smaller courtroom, but it's still something that they've never done, right? So, and this is something that needs to be taken into consideration, especially if you're dealing with clients who, they're working people, right? They're salt of the earth people. They don't have a law degree, a medical degree, but they still deserve 100% excellent representation in court. And the question is, how are you going to go about and get that? And the way you're going to get that is, you got to prepare them. You got to tell them, look, very few law firms have access to, if you will, a mock courtroom, right? Very few law firms have access to that. Some do. If you have access to a law school that you want to take your client to and say, this is how a courtroom looks, that would be a great thing. But something even more common sense, if your client has time, I think what is a good idea is to bring your client to court one day before the trial actually happens, right? And just have them sit in the audience with you and say, look, this is the way the courtroom looks like. You're going to stand up there, but it's just a courtroom. It's a building of justice. That's the important thing for people to understand. They do justice there, but you need to bring the client, sit down and see it before it happens, right? And you have the right to. It's a public and open courtroom. I think that kind of takes a little bit out of the stress. You might not have access. The court clerk, if he or she is nice, might let you pass the bar with the client, and have the client sit at the counsel table with you for a little bit of time, and then just thank the clerk, and then after the client feels comfortable, you guys can leave. Go get lunch with the client in the courthouse. Show him the courthouse. Show her the courthouse. Just to, if they have time, and if they don't, right? And if the trial is in, LA County and they are in Riverside, you might want to drive out to Riverside County and take them to the main historic courthouse. Say, look, it's not the same one, but it's the same idea. That's something that I think actually helps people, because it helps for the client to see the way a courtroom looks like, especially if it's that courtroom that you're going into. And one thing you want to do on direct examination is you want to make sure that the client feels comfortable up there on the stand, which is why you're bringing them in the courtroom. And you want to explain to the client some really common sense things which really don't apply sometimes when the client is up there, which is, it's a conversation with the attorney. And think of the jurors, and this is sometimes difficult, as they're also people, right? They're people that, for lack of better words, were brought in with a summons off the street, from their homes. They're regular citizens, and they're just there to hear the facts, right? The judges, you should just tell the client they're not there to judge you. They're just there to look at the facts. And you want to, as much as the best way to make the client prepared and to make the client feel comfortable is you have to do a lot of preparation with the client. You have to, in a way, disabuse the client of any notions of fear. And the only way you're going to do that is through more and more preparation, right? It's like exposure therapy. The more you do it, the more likely the client is to feel less and less worried, right? So a client that you spend and you meet them in person, this is the most important thing. If you meet the client in person, not just in your office, but you meet them at a Starbucks, you meet them at their home with their family, you meet them at a restaurant, you pick up the tab, all that kind of stuff, that's going to make the client feel more comfortable. The direct examination does not begin on the stand. It does not begin during trial. It begins when you picked up the case, when you signed up the client, before the deposition, when you prepared the client for the deposition. The client needs to know that you're there with them, and just saying it is not going to do it. You need to be there with them from day one, right? I give my clients my cell phone number, and I do it for a reason. If they have an issue, they can call me. And if you've ever had any issue in general with any kind of professional entity, whether it's a doctor, a lawyer, a dentist, or whether you've had an issue with a health insurance company, you know how frustrating it is to pick up a phone and dial, and you get the prompt, press 1 for this, 2 for this, 3 for this, or you get the, AI, artificial intelligence, call us back or do this or that. Giving your client your cell phone is going to go so far with the client trusting you. And they'll call you, you text them, you tell them, look, give them updates with the case. Sorry, the case is being continued. We can meet in 2 weeks to discuss, to prepare you for your direct examination or prepare you for this. That's extremely important. The trust will move your case so much further on direct examination. So what's the purpose of direct examination? So if your client has been deposed, which there's probably a 99% chance that your client has had his or her deposition taken, you want to make it clear to the client that what he or she is doing on the stand is basically similar to the deposition. And you want, if you will, you want to look at the deposition transcript, Hopefully you were the same attorney that were dealing with the case back then. If you're just a trial lawyer, like I am on many cases, then what you need to do is you obviously need to read the deposition with your client and see if there's any problems with it. So what that means is usually sometimes clients forget stuff, and you need to consider how you're going to prepare the client with stuff that they forgot in the deposition. Because one of the things you got to remember, and we did a video on cross-examination already, is the direct exam is going to be followed by the cross-examination. So if you have a client that remembers everything on direct exam, you just prepare them phenomenally, and they get cross-examined. Obviously, they're going to get cross-examined right after that. One of the things that any defense attorney is going to do is they're going to take a look at the deposition transcript. They already have it ready, and page aligned, and they're going to say, well, you didn't remember this a year after the accident, but now 3.5 years later, somehow you remember all this. It's you need to consider what the client remembered and what the client didn't remember. So that's an issue that you're going to have to look at, because nobody's going to have a perfect deposition transcript. Nobody's going to have a perfect deposition. So number one, it's the client's story, not yours. You almost want the client to talk in paragraph forms until the defense attorney says objection narrative, meaning basically it means objection, let's hear the next question. That's a very effective direct examination. So if somebody was direct examining me and they said, Mr. Genshu, can you tell us where you're from? I would tell them, look, my name is Vlad Genshu. I was born on June 21st, 1986, in what was then communist Romania. On December 11th, 1991, I had the good fortune to come to the United States with my grandmother. We flew into JFK International Airport. I'll never forget, my first time that I came to America, and it was a pretty big event. My mom had already come to America on January 3rd, 1991, and we lived in Pittsburgh, Pennsylvania, where my mom was getting her education at the University of Pittsburgh in chemical engineering. From 1991, we were there until about the summer of 1996 when we moved to West Virginia. My mom then worked at Union Carbide in West Virginia, in Charleston, West Virginia, from 96 to 2000 as a chemical engineer. My dad came to America in 1994. He also got his PhD, just like my mom, at the University of Pittsburgh. And what you're really getting there is you're getting the client's story, right? So if you get all of that, the client is actually presenting themselves as who they are, right? It's not just, where are you from? I'm from Romania. When did you come here? 1991. You don't want those guys. That just looks stilted. It's not good. You want, and the thing is if you didn't spend time with your client, if you didn't, if they were just a file number to you, which they're not, if they were just a file number to you and you didn't spend time with them, you're going to get a one-sentence answer. You need to have the client feel comfortable with you. You need to have the client feel comfortable with the legal system, which is difficult many times because they've never felt it before. They've never dealt with it before. So that's something that needs to be done. So again, you ask the client, can you tell us a little bit about your educational background? Yeah, I went to high school. I went to middle and elementary school. Elementary school was in Pittsburgh, Pennsylvania. I went to middle school in West Virginia, in Charleston. My high school was in Radnor, Pennsylvania, when we moved back to Pennsylvania in 2000. And I graduated from high school in the year 2004. Can you tell us where you went to college? You say, sure. Yeah, I went to college. I went to Georgetown University. I was there from 2004 to 2007. I graduated with a bachelor's in science and foreign service, and I cum laude in 2007. After that, I held a couple jobs. I then went to law school, came out. First, I went to Widener University in Delaware for a year. Then I transferred out to Loyola Marymount University, Loyola Law School in Los Angeles, California. I graduated in December 2012, and I passed the bar in July 2013, and I was admitted to practice law in California on December 4th, 2013. Now, it's okay if your client do not have all those dates, but you're getting through basically what's going on. And then you ask the client, okay, can you tell us a little bit right now or in the past 5 years? Tell us a little bit about your work history. Yeah, sure. I've been employed doing this, that, and everything else. Lawyer, whatever you want to get through client. It has to be a conversation, okay? And to me, and it depends on the judge, right? I don't like to sit behind the lectern I have a tendency to maybe walk around too much. If you don't want to sit behind the lectern, I don't like to be, if you will, married to the lectern, where you're holding the lectern on to dear life. Just, you can walk around a bit. Don't do it too much. It might annoy the jury. Don't move your hands too much. That might annoy the jury. I've unfortunately sometimes do that. But again, simple conversation with the client. Mr. Smith, have you ever been involved in any other car accidents? Yeah, I was involved in a car accident back in 2007, and then have them talk about it. Have them talk about if you had any injuries and all that kind of stuff. You have to know all of that, right? And you'll know all of that if you have a deep professional relationship with the client, meaning the client feels comfortable to call you, to talk to you. Okay, that's a very important thing. As a personal injury lawyer, and this is something that Carl Douglas told us at Plaintiff's Trial Academy. Personal injury lawyers represent people. Insurance defense firms represent entities, right? Personal injury lawyers often represent multiple members of a family, meaning, you might represent the brother in the year 2006, the sister in the year 2015, and then you might refer out, the cousin to another attorney for a real estate issue. If you're representing a family, sometimes you're representing individuals. You're not just representing a business with 50,000 employees. There's nothing wrong with that. There's nothing wrong with representing a business. But when people come to a personal injury lawyer, they're not coming because of the firm. They're coming because of the individual attorney, right? They're not coming because it's a firm that an insurance carrier has a very strong relationship with, that they've given 500 files to over 6 offices throughout the United States. So you have to give that personal attention to your client. That's going to help you on direct examination. So direct examination isn't just, again, what's happening on the stand. It's how you get there, that you've given your client the time of day, that you've told them, listen, your case has been continued. And we're going to talk about when we can actually meet and sit down, given that we have that continuance, a little bit more time. The basics that you want to get on direct examination are the, who done it, when did the accident occur, how did it occur. But again, you have to realize that you're working with things from the past. You're working with the discovery responses, right? So you're working with what your client said in written discovery. You're working with what your client said in deposition. You're working now with what you have on the stand, and you're preparing for cross-examination. The most important, one of the critical things about trial is credibility. Credibility is, if I said preparation 3 times, I think we got to say credibility like 20 times. Remember, cross-examination is the crucible of truth. It's going to come right after direct examination. It's something you always need to remember. One of the things that I was taught to do on direct examination, which I think is a good idea, is if you think that something is going to come up on cross-examination that's going to be a problem, you might want to address it yourself on direct examination. It's kind of like putting up a pillow in front of your client, or in front of the question that's going to happen before you get hit with it, right? So you kind of can take some of that blowout. So if you know that they're going to cross-examine your client really hard on an accident that happened 2 years before, ask the question yourself and have them explain it. If your client, didn't understand all their medical treatment, try to ask about it yourself on direct examination. So because that cross-examination is going to happen. So when you're dealing with that's what you're really working with. The foundations of cross-examination are credibility and the things that happened in the past, the deposition, the written discovery, and then what you're looking towards immediately in the future, which is your cross-examination, the cross-examination by the defense attorney. After the cross-examination, which is not fully limited to direct, obviously, they can bring up stuff from the past. They can bring up impeachment. They can bring up, again, the discovery, the deposition. Your redirect of their cross-examination is limited to the cross-examination. So remember that. If they didn't bring it up on cross, you don't get to redirect. And the redirect should be imagine it like a funnel. The direct exam and the cross-examination, then it's getting funneled into the redirect. Then they can do a recross, which is based on the redirect. But the important thing to remember is the client is the star. The client is the star on direct examination. The client should be doing the vast majority of the talking on direct examination. The lawyer should not be leading the client on direct examination. The lawyer should be allowing the client to talk, to expound on what happened to them so that the jury understands, right? And then in terms of some more specifics, we are, if you will, a visual society. We like to see stuff. If your client is stating that stuff happened and to them in terms of activities of daily living, it always helps if you have it in discovery, if you brought it up in discovery because you had to produce it in discovery, for you to show it to the jury. So if your client is saying, I used to, ski, surf, snowboard, etc., and this car accident made it impossible for me to do that. If that's true, and it must be true because they're taking the oath to tell the truth, you should have produced in discovery the things that they could no longer have done, right? With the photos. It's almost like a before and after, but not in a traumatic brain injury, quadriplegic case. It's not that kind of before and after. It didn't totally change their life, but if you have those photos of them skiing, a year before, if you have them photos of doing those physical activities, the videos, and you had to have produced them, of course, to defense counsel in discovery, right? You can't sandbag the defense counsel. You can't do that. You have to be ethical. You have to give them that. So when you have those videos, those photos, you produce them in discovery, and then you put them as exhibits on your exhibit list, and then you show them. You say, Your Honor, you say, Mr. Smith, was there anything that you used to like to do, or you used to do before this car crash of November 26, 2021? Yeah. What? Well, every late January or late December for New Year's, we would go to Big Bear. We'd rent a cabin, and we'd go to Big Bear, and we'd snowboard with the kids, and I'd ski up there, or we'd do this, or we'd go to Yellowstone, and or we'd go to this national park. It was a family tradition. And then you back it up with and you say, do you have any photos of that? Yeah. Did you ever take photos of that? Yeah. I took photos of the last 2 or 3 years. You say, okay, Your Honor, permission. I have a 8x12 document. It's entitled, I'm going to label it Plaintiff's Exhibit 1. Shows a photo of Mr. Jackson with his family at Big Bear. I've shown it. It's already in the exhibit list. I'd like to publish it. There's not going to be any objections. It's already there. And you probably say, do you see what this shows? And you can go up there, or maybe the judge just let you put it on the Alamo and publish it. You say, you see what this shows? Yeah. Well, who is this? Well, it's me with my family. What year was this? 2020. Well, was this before the car crash? Yeah. And when was this car crash? Well, it was November 2021. Was there any photo in 2021 in December? No. Why not? I wasn't able to go up there anymore, right? If you can show what happened visually, that's a big deal. I've had jurors, after I've tried cases, where they've said, listen, we believed your client, but we didn't see anything. We didn't see any photos. We wanted to see some photos of what changed, right? And other things that you want to bring in direct examination are photos of the property damage, right? So you're not just asking questions in direct exam, you're introducing evidence. So you want to bring up, okay, so how would you call this car crash? It was a rear end impact. How would you describe it? I describe it pretty bad, major impact, okay? And Your Honor, I have, and again, you lay the foundation. Do you remember the day it happened? Yeah, it was November 26, 2021. Do you remember what time? It happened about 7 p.m. Okay, anybody else in the car with you? Yeah, it was my wife and my 2 kids were in the back. What kind of car were you driving? Well, I was driving a 2015 Ford Edge blue car. And do you remember what kind of car you were rear-ended by? Yeah, I was rear-ended by a Honda Accord. I think it was, I don't remember, 2012. I think it was 2012. And it was a silver car. Okay, and how many impacts do you feel? I felt one impact. At the scene of the car crash, did you take any photographs? Yeah, I took about 3. And what were the photographs of? It was the rear end collision, and it was also the rear end hit, and I also took 2 others of a little bit farther back photos, okay? Your Honor, I'd like to introduce Plaintiff's Exhibit 1, or whatever, you're up to 3, and then you describe what it is, It's a photograph, 8x12 photograph, showing the rear end impact. The two cars crashed into each other. Copy has been shown to defense counsel. Your Honor, permission to approach. The witness to show him approach freely. The judge would usually say, no problem, you go ahead. Go up there. Granted. You go up there, show it to him, go back. You see what's shown here? Yes. What's shown here? It's a photograph of the two cars. Did you take that photograph? Yes. Does it accurately show the photo? When was that photograph taken? November 23rd or whatever, November 26, 2021. Was it taken at the scene of the collision? Yeah, it was taken right then and there. I took it. Does it accurately show the two cars that were crashed into as a result of the car crash? Yes. Boom. Permission to publish this and show it to the jury. So there you go. You got that. You're probably not going to be able to get the property damage in. It's hearsay. You're probably not going to get in any medical bills to show it to the jury, but they can describe it. So that's something that you are going to have. You want to have them talk about it honestly and truthfully, and you want to have them show it, right? Show me what you talked about. And then you're going to and then you're going to get cross-examined. So that's what you want on direct exam. Your client to explain their case to the jury with their words, right? With their photographs, if they have any videos, basically what happened, deeds. Actions speak louder than the words, and the words that speak all have to be truthful. Best of luck in your direct examination when you go to trial.